Good morning. I'm so glad to be here on such an important topic. And I am just thrilled to introduce to you first, our first speaker this morning, Judge Brent Carr. And okay, so here's what I learned about Judge Carr. You are a true expert in your field when you can make songs out of the subject matter. Okay, so I met him in person because I'd seen him virtually now for this last year. I met him in person at the reception, and you know the childhood song, you got your leg bone connected to your ankle bone? Okay, he's got that going on for this topic. He says, okay, you got your PD connected to your sheriff, you've got your mental health expert and your magistrate. Like, I'm telling you, that's the true sign. We know we've got an expert here because he can do that. So Judge Carr has been the presiding judge of the Tarrant County Mental Health Court since 2003. The presiding judge of the Tarrant County Veterans Treatment Court since 2010. The presiding judge of the Tarrant County RISE program for sex-trafficked women since 2011. And the supervising judge of the Tarrant County Enhanced Mental Health Services docket since 2015. He has served as consultant for numerous specialty courts around the state, was the inaugural chair of the Tarrant County Veterans Coalition, serves on local nonprofit mental health and substance abuse agencies, and currently serves on the HUD-required board of the local Homeless Coalition, on the Governor's Specialty Court Advisory Council, and as chair of the Office of Court Administration Advisory Council on specialty courts, and is frequent lecturer at local, state, and national trainings on mental health-related topics. So I saw him, we happened to walk in together this morning about 7 o'clock. I said, hey, you ready to rock and roll? He said, I'm ready to rock and roll. So with that, Judge Carr.
Thank you, knowledge travelers. My goal today is I want to lead you to the light. I want to place my hands upon you. Well, that's probably an ethics violation. I'm not going to do it. I'll just stick with the script. And welcome to you also out there in virtual land. Let's go ahead and start my clock here so I can make sure I stay on time. And I've got my expert timekeeper down here as well. Well, this is our historic courthouse, Tarrant County, founded 1849, named after General Edward Tarrant. We're the third largest county in Texas and the 15th largest county in the nation. This is the building that I work in, the Tim Curry Criminal Justice Center. If you look at the left of the picture, my office is the second bank of windows in the middle from the top. I've got a great view to the north, so if we're ever under attack from them Oklahomans, I'll see them coming. Since this is a mental health conference, I included a picture of our mental health court team. Very proud of this group. Three of the people in that picture have been there since the program started in 2003, and the rest of them all have long tenured services with this program. So continuity has been a very good thing, and I guess I should pause here. That is, we're very proud of receiving this year's Ruben Reyes Award. Many of you knew Ruben. He was a giant in the mission of specialty court undertakings, particularly drug courts. He is sorely missed and was just a great Texan and a great American. So today, I mean, there's just so much to talk about. It's like total oceanfront in the area of ethics. So I've had to pare it down to a couple of things. This is not going to be comprehensive, but we're going to look at competent and diligent representation and judicial ethics as they primarily apply to specialty courts, which I hope a lot of you in this room and out listening virtually, judicial officers are considering. And there are plenty of resources around the state to help you get started in that undertaking if this is a path you desire to tread. I'm originally from Florida. I was in the Marines, South Texas College of Law. assistant DA for about 8.5 years. I've been in my current elected position for over 30 years. 1 year, 2 months, and 15 days, I think, is the countdown. But who's counting? I don't know hours and minutes. That's a little too anal, but I do have a general awareness. These are the programs. I need to update the bio a little bit. I do currently still preside over the mental health and the veterans program. You're going to hear from Judge Nguyen. She's seated right over here. There she is right there. She's going to tell you about the rise. She is now the managing judge of that program. And if Rainey Webb's listening back in Tarrant County, coming up with the idea of enhanced mental health services, which is basically a program for chronic, frequent offenders, a lot of criminal trespassing, those sort of things. And she also runs a marvelous program. And then we launder all of the cases through my court, and we certainly collaborated as we were putting that program together. So let's start off with an ethics question. Why are you here this morning? Well, dig deep. Put a proverbial mirror in front of you, reflect on that question, and there's a list of possible answers. The continental breakfast looms large on many of our desires. For the lawyers, we also know that we can only get 1 hour of self-study credit for ethics. So the great thing about this conference, as you heard Christy say yesterday, you're going to get all of your ethics requirements just through coming to this course, and along the way, hopefully leave you a little bit more informed than before you got here. So I want to lay a little bit of landscape. I don't want to get too deep in statistics and numbers, but it is an important backdrop to many of the issues that we face. So. In the business world, anytime you have market share that deals with over half of your customers, you would think that ought to be a priority, and it would receive a lot of attention, both in work and resources. And I do believe that we're evolving more and more in this area. None of us are going to have everything be where we'd like to have it by the time we flip the light switch off for the last time. It is a process. But as you can see that the confinement, now this is confinement population. We're here hopefully to spend a lot of time addressing people who we've diverted from confinement, but just as a measuring stick, because they're an easier population to evaluate because we know where they're at. So we can see that mental health is by far a more prevalent issue than people who end up with criminal charges, and at 4 times the rate, serious mental illness is prevalent amongst people who end up in incarceration. And least I forget to say, I want to echo a few things that in discussion with Professor Brian Shannon, Texas Tech University. 1622, the early identification of people with mental illness, it's not for people who are having acute mental health crisis. I defy you to show me where in the statute it says that. It says that the sheriff, who once they receive information that a person who may have a mental illness, shall notify a magistrate within the designated time period. So even if they're currently well adjusted, they may be on medications, we still need that notification so we can continue continuity of care and making sure that we're keeping people in a place to where their matters can be resolved. The cost of incarceration, now these are the basic numbers that don't include inmates that need extra care for mental health or even physical health services. But you can see down at the bottom, that's $133 million a year in cha-ching every night. There goes another $365,500 for the average 42 inmates that are in the Tarrant County Jail. So again, in the criminal justice system, mental health is a player more than 50% of the time, maybe a little less than 50% if we're including all of the out of custody people, but whatever the number is, it's a big number. All right, so let's dive into the meat of the presentation. So we have basically a structure that is of a grievance system that is managed by the State Bar of Texas. That is the Texas approach. Some jurisdictions, it's all in a court related type of a process, but in Texas, our state bar runs our attorney grievance system. There's basically two issues that go through filing of a grievance. The grievance is the written accusation of the misconduct, and a complaint is if upon review it's deemed by the disciplinary counsel's office that it should continue, well, then it turns into a complaint. And here's what happened, the breakdown of sanctions by the top 5 areas of law. Well, this is not true. It's not true, but there's that saying out there that, at the criminal courthouse, it's bad people on their best behavior. At certain entities in the civil arena, it's good people at their worst behavior. Well, that generalization is not completely true, but if you add all the civs up, it's 93%. Well, a big chunk of all of these cases. It's about, I didn't do my math right, I guess here. That's 57, and personal injury, another 14. So 71%. I'll leave the probate people on their own. But here's the top areas of misconduct. And it's communications, neglect, and integrity. So some form of dishonesty, failure to communicate with a client, or neglecting a legal matter that has been entrusted to the attorney to care for the client. So now these numbers are not going to carry over year to year, because obviously at the end of one fiscal year, there are still unresolved cases that continue to pen. But in the last annual report of the State Bar that I use for my source material, you'll notice a little 6 up there in the title. That's my footnote to the end, where I've included the links to all of the materials if I didn't otherwise set it out on the page. But you can see there were over 7,000 grievances filed, of which about 29% resulted in a formal complaint. Many of them were summarily dismissed, and here are the outcomes from 2019 through 2020. And that also is kind of a list of the options that is available to the grievance committee's recommendations, or if it ends up going through a court process, that is kind of the options that are available throughout the process. Remember, a grievance is not a criminal matter. It can certainly be as a result of criminal matters, but grievances by themselves are not criminal. But they can also result in some rather significant discipline, even when there's no crime involved, such as neglect or failure to communicate with the client. And as I have flipped through the bar journals, those seem to be the top 2 issues. I'm not going to say that there aren't some attorneys who don't take advantage of a situation, and they shouldn't. But neglect and failure to communicate seem to be the top 2 issues, and these are the things that need extra attention by practitioners to make sure that we're staying on top, and we'll come back to these things in a moment. We have a number of presumptions in law as this relates to representation of mentally ill clients. Well, everyone is presumed competent to stand trial. Well, they're also presumed innocent. And they're under 46C, they're also presumed sane. Well, sometimes that presumption, as we're going to see in a moment, flips the other direction, and some steps have to be taken in order to restore competency. And there are some traps and pitfalls for the unwary if you're not paying attention to what you're doing, and I'll have some examples for you in just a moment. So you can read these later. We have a health and safety code definition of mental illness. We have I took this from Health and Human Services definition for intellectual disability, and from the National Institute of Health, a definition for traumatic brain injury, which are basically the three issues that we deal with in the area of mental health matters. I like to always make the point that mental illness, brain injury, intellectual and developmental delay, these are not things controlled by willpower. These are, surely as someone may lose an arm or a leg, they are a part of their life that they have to live with. And over my many years now of having worked with mentally ill people, it's basically about how well they can adapt given the circumstances they have to resolve in order to achieve the best quality of daily living. Most mentally ill people are not dangerous. They're not in the criminal justice system. I'm not asking for a show of hands, but I know in this room there are several people who are taking depression medications, anxiety medications. So it has an impact across a very broad scope of people. But there are a few, and I can think of we had an incident in Fort Worth involving, again, when something like this happens, it's always my worst nightmare. I always go to bed fearful that some morning I'm going to wake up and there's going to be some horrible tragedy involving somebody that was in my program. And that can be a program killer, particularly if it's a newer program and if it doesn't have much traction yet, and you don't have over 600 graduates like my mental health court program. But it'll come. You guys will lose some hair and it'll turn gray. You ladies will do whatever you do, and it'll come, and you'll all see programs flourish and mature. But it just takes persistence and dedication, and people want to work in these areas. There are people who I work with that I'm sure could make more money doing other things, but this is God's work, to borrow a phrase. And I can tell you that in my life, when I turn off the light switch for the last time professionally, that I've got the DWI trial. I'm up to, my court reporter tells me we're up to 984 trials. So I got to get to 1,000. It's just a number, but I got to get there. But I've got the art of the DWI trial down to a science. And but working with these people, they're interesting, they're dynamic, they present situations that you just won't experience anywhere else, and the transition they make from, I can remember so many people who came in a total train wreck and who left fully functioning, working, reunited with families. Anecdotes, as Dr. Fabello keeps reminding us, are not evidence, but if you follow the evidence-based practices, these things will come. So I like to think of it in terms of this model. The capstone of dangerous represents the least number of people in our system, and the work that I tend to do is the lower risk people. Now, I don't mean low risk in the sense of, for those of you who are NADCP aficionados, Dr. Marlowe's risk needs quadrangle. I mean lower risk to public safety and things of that nature. So there's plenty of low-hanging matters out there that you just have to reach up and pluck. And I'm not going to say that doing something is better than doing nothing. You do have to do a responsible something, but there's a lot of resources out there, and there's a lot of people who are willing to provide you their time and their talent. And there's some COVID money out there I hear somewhere. I keep trying to find it in my county, and one of our county administrator people is sitting over there, Mike Laughlin, and I want to know where that goddamn COVID money is, because I want some of it, and so you, by God, better come up with it. That's what I'm telling you. So I know it's out there. So in the preamble of the Disciplinary Rules of Professional Conduct, well, you didn't know it, attorneys, and for those non-lawyers, this will hopefully give you a little bit of insight into the kind of rules that we're bound by. Well, this is the list of things you're supposed to do. Now, you can look at that list and you can go through those rules, and I want to hit on one in just a second about where you might have to take steps to protect other interests of a client. Well, I'm a criminal lawyer. I don't get involved in that guardianship and all this other stuff. Well, the rules don't make an exception. There is no criminal lawyer exception, and you got to do the whole enchilada when a matter presents itself. So it's not enough to just look at a representation, particularly of a mentally ill person, as a linear concept. There's going to be a lot of off ramps and on ramps that you're going to have to navigate and negotiate to get yourself to a good place. Well, some other roles you might be called upon to play if you read the rules. You may have to, are there, if you have an awareness of some matters that is going to cause the person to lose a lot of their resources and ability to, I'm not saying you necessarily have to do it if you're not the person whose expertise involves that, but you may have to network. You may have to come out of your comfort zone. You may have to do a few things that people are not normally called upon. So it is my view that just like officers are now required, I believe it's 40 hours minimum of mental health training. I think it is my view that because, again, this is not picking up a penal code and looking at a statute and saying that, well, the punishment range for assault bodily injury is up to a year in jail and a $4,000 fine, because what might be driving the assaultive conduct is a significant mental illness. We have many people in our program that is their charge, and they are there with the victim's blessing, because that is one of the prosecutorial roles, to interact with the victim to make sure we're all on the same page here, and we certainly need to respect that role. But these are people often who are never going to be able to work. Social security disability income is going to be their primary source of support, and there's just no other place for them to go. So we have to work hard to figure out good solutions. So I want to talk about competent representation of individuals with mental illness. And I first want to start with sources of information. Now, some of these are very obvious, and I hope they're very intuitive, so I'm not going to spend a lot of time addressing them. But there is a screening form that is required by the Texas Commission on Law Enforcement for suicide screening, medical, mental, and developmental impairments to be completed on all persons admitted to the jail. So if you're a defense attorney, and if that form is supposed to be out there, the Jail Standards Commission to certify jails require that certain screenings be in place, particularly like the 1622 screening. And again, I want to pound, it doesn't say acutely mentally ill people. It says if you become aware that a person has a mental illness, you must report it to the magistrate. And then it's the ball's in the magistrate's court to decide what direction to go after that point. We also have something in Texas called the CARE system. Now, I was rather perplexed. I knew that was an acronym, and I called our local people, and a lot of them are sitting over there, and they told me that CARE meant a client-assigned registration system. And I kept looking around for the E. There's no goddamn E. Well, there's one in system, but it's one of them little E's. And so I guess the best I can figure out, it's the registration, the RE. And if there's a mental health professional that after I'm done here who can clue me in, you can come up and tell me. But this is it's a database for all people, regardless of where they have touched the state mental health system. They're there. They're there, and there's information. There's mental health treatment providers. I'll come back to that in just a second. I've already pounded on the 1622 reports, as we heard Professor Shannon remind us. It's now supposed to go in addition to the judge, the defense, the prosecutor, but also to the sheriff. And go figure, the sheriff's the one doing the reporting. Shouldn't they get a little bit of feedback on what they reported? So it comes back to the sheriff, and that's, presumably the sheriff can use that information to coordinate with their in-jail medical staff to make sure we have medication continuity, and that is something across the state we need to do a little bit better of. That's been a failure in a lot of situations, so that area can certainly use some more plowing. I am no HIPAA expert, but basically there's and John Petrella, who's a member of the commission, he is someone that I look to for expertise and I consult with when I have a situation. And so basically there's I don't know if it's big enough to drive a semi, whatever your analogy is, but it's a big gaping hole as far as criminal justice system access to what would otherwise be privileged information. Of course, as an ethical matter, we always want information used for an appropriate purpose. We don't just want to willy-nilly be scooping up people's personal information because we can. But again, with proper training and experience, you lawyers know when you're dealing with a client where you need additional assistance and information. And so under HIPAA, you can either get a signed, if you care about it, you can get a signed release, a court order if the agency isn't cooperating. HIPAA is very clear that for covered entities under HIPAA, that once you show up with a court order or a court subpoena signed by a judge, now if it's not signed by a judge, you have to attach another explanation of the relevance of the information. But that information is available out there, and certainly if you're representing, and these are oftentimes going to be indigent defendants, so you certainly have the judge's ear if you come up with an agency that is being a little less than cooperative. Why not use the HIPAA release form? I mean, that makes the providers feel better. There's a website that'll take you straight to it. It looks like it's a very simple form, so it probably wasn't drafted by a lawyer, which can often be a good thing. But it's a very simple form that you can print out and on your Quest. The other thing with regard to competent representation is knowledge, and there's just no substitute because I do look at representing mental ill people. A guy named Robert, when in the mid '80s, when I walked into the 213th District Court, Janice Pulliam, the clerk, begged me to take a look at this case. So I was the low guy on the totem pole, just showing up for my first felony assignment. And obviously we didn't have computers, widespread use of computers at that time. So she had 3 thick files that only went halfway up the documents because they were so jammed full of papers. Robert was charged with attempted murder. He had been in and out of the state hospital system, and this is well before we had the limits in place that we do today. We didn't even have 46B at the time. It was 46-0 something. and it was a very convoluted process, and he had just been bounced back and forth between the state hospital system, and he'd just been sitting in the Tarrant County Jail since God knows when. So she asked me to look at it. I don't know if I helped Robert or not. We ended up sending him back to the state hospital because regardless of what I thought about him, when I finally laid eyes on him for the first time with his matted hair and totally unresponsive features, and in those very profound cases, there's no question that this isn't a faking situation. That their pallor is bad, very withdrawn and shriveled. So Robert desperately needed some care, and so again, I don't know if the can got kicked down the road, but that was my first sensitization to the things that come up. So I've always looked at mental health like a freeway with off ramps and on ramps, and education has been the key. And even preparing for this presentation to force me to flip the pages in the rules of disciplinary conduct and the rules of judicial conduct, I love setting where you're setting because I always like to hear people much smarter than me who have an expertise that I can know just enough about, not to be dangerous, but to at least know where to go when I have a peculiar, which I might consider a peculiar question on how to best resolve a case involving a person with mental illness. So education, and one of the things you can do, we're going to have part of my gifting as I head out the door. I hope to have 2 conferences for local attorneys next year. We're going to have a mental health presentation. We've done it twice in the past. We call in our local people to give presentations. If you're having some difficult relationships with some of your local providers, well, invite them to be a speaker. That kind of butters them up a little bit. They can stand in front of the group and feel important and share what they know. And that has achieved a lot of breakthroughs. Although I'm very proud to say that Tarrant County is a very collaborative county. We've talked a lot about 1622. Well, I still hear a lot of cases where jails and municipalities are not using it at all, or if they are using it, they're using it for a much less restricted purpose. And I'm not here to make your day bad. I'm just here to tell you what the law is. And there is no exception in 1622 that it's a limited application to acutely mentally ill people. That is not what 1622 says, but it is a valuable piece of information. Now the next thing is, once it gets delivered to people, defense, prosecutor, the court, the sheriff, the CSCD, well, now we need to actually look at it and use it, because somebody with the right letters after their name, if they have found this person has a mental illness, has also included a treatment plan. And if this person is going to make bail, particularly under one of these mandatory release statutes, if they have no violence in their past, well, then we want these conditions in their bond conditions. We want them to go to the treatment facility. And you may have to kind of be a little bit of an ad hoc mental health court if you get feedback that although that it's on the bond condition, the black robe effect is a powerful effect. And you can bring people back before you and kind of lay out the pros and cons and the consequences to act or not act. And you'd be surprised how after just one-on-one chat, if the initial bond conditions were not embraced, will actually move the ball down to the next level. We're fortunate in Tarrant County to have an agency called TCAT, and it basically is a predisposition mental health case management agency. So we basically provide services to people while their case is pending. It's been a very good program. So we also have 17032, the release on bond. Again, if you have a client, particularly in jail, and they're not hung up by the current or past violent offense matters, then it says, I believe it says shall. I believe that's in there somewhere also. Shall release without money bond. But again, these are low risk, nonviolent offenders. There is a, can I say a legal term? An adjustum generis. I haven't used that word in God knows how many years, but that just basically means there's a catch-all clause, and I thought it meant something to do with orange juice or something. Get that, de-juice them oranges and have yourself a glass. But there is a catch-all. Maybe there's no place for them to go, and it's the dead of winter. I don't know what the reasons are, but there is the judge does have a discretionary option, and there are other requirements that are a part of 17032, but you have to be familiar with what it says, and there continues to be the requirements. Well, what about diligent representation? Well, sometimes you just have to keep digging. Now, here's a trap. Well, let me just jump ahead. I just want to jump ahead to this guy. That's second page, third page, fourth page, fifth page, sixth page. And actually, I looked him up before I came here, and I can add 5 more. There's about 15 entries per page. This is all public information, just the case and the case number. There's about 5 more I could add to this last page here. Well, this particular person has a history of being restored, but I only bring it up to you because you might have a client that looks like this, that buried in one of their past cases is a finding of incompetence. The case got dismissed. So remember that presumption of competent? Well, that's no longer the presumption. The presumption is now they're incompetent, unless there's a judicial order finding that competency has been restored. So you got to look at that, and you might have to dig through several cases to find that out. And then sometimes you also have a person who has a report of incompetence and not likely, their competence is not likely to be restored. And you know this within the first 30 to 60 days of their incarceration for a low-level offense. There's not a good solution here in a lot of cases. Sometimes defendants, and I'm not going to take Tarrant County out of the footnote here. They sit in jail until the maximum for their sentence has been served, and then they're let out because there's nothing more that can be done. Now, the state has a right to have a conviction in appropriate cases, but these are problems that have to be grappled with. So basically, the disciplinary rules say that, and there is one on dealing with mentally impaired or impaired clients. The context of the rule, it seems to be suggesting it's dealing more with civil matters. That might be its genesis, but it does not make that distinction. There is no specific criminal lawyers. You don't need to worry about this, so you do need to worry about it. You're supposed to, as best as possible, continue to make a normal client relationship. Take reasonable steps to prevent physical, financial, or other harm. It doesn't say just for civil attorneys. So you may have to develop go-to people that you can consult with. And I know that's an issue, time and money. A lawyer's advice is their stock and trade. And we all need to support ourselves, but the rules are the rules. You can disclose information to a reasonably extent possible to achieve appropriate representation interests. And when it's all said and done, as long as you've done everything you have to, a client is still, even an impaired client is still entitled to make a bad decision if they want to. But making sure that they're doing this competently is really the key. Signing documents like plea bargains, if you have reason to suspect they're not competent, that's just not a good idea. A lot of times we get experts' reports, and there's an agreement with all sides that the person's incompetent, but the defendant doesn't want to be incompetent because there's enough still going on where they know what that means. There's a months-long wait to get to the state hospital, and we're going to start a process that everybody else charged with the same crime would have been out of jail a long time ago. So there does need to be more collaboration and some legislative insight into a lot of these things, and concerns about, what time of day, that number 4 there, what time of day does a person get discharged? Do they get discharged with medications? If they're on medications, all of these things have to be taken into account. These are questions that I was asking, all of these numbers here, I was asking defense attorneys to just give me their comments on. Sometimes you need to get some information with family members. You have to share a little bit with them. Prosecutors know they're supposed to turn over mitigating information. We're never going to lose sight that public safety, both to the client and the general public, is paramount, particularly if you have an unmedicated person with a tendency toward violence living with an elderly parent. That has to be taken into account. But we also have to remember, lawyers and judges, that we're not therapists. There's a few of us who, after their names, have some letters that allow us to make those determinations, but not many. I'm going to skip through a little bit of this so I can get to the judge part. Again, don't neglect, carry out your obligations. Just because somebody has a significant mental illness or an intellectual disability, you still got to keep them informed. You've got to make the effort, and it should. And I remember old Richard Anderson. For those of you from Dallas, he used to give ethics presentations. He was always encouraging, make sure you make a note. Make a note in your file as to when this happened, even if your interaction was not fruitful. I think that every DA's office and public defender's office should have if you're of any size at all, and most of them around the state do, should have attorneys that deal specifically with mental health. And if you're in a rural jurisdiction, you still have to develop, and hopefully that can maybe be done through an information bank that the commission can work on to still give you a resource to basically investigate some of these questions when they present themselves. Non-adversarial approach, it's still in the history of law a recent phenomenon, and this cartoon, I'm really not, this is more appropriate for a discussion of specialty courts in general, but it kind of makes the point, of the different approach in mental health cases. Well, in answer to the question that the person is asking, the answer is it depends on what part of the program you're in. You can't ask a person who's been doing drugs for 20 years to all of a sudden magically stop. I know we've gone through times of zero tolerance and other issues. What we succeeded in doing is aggravating our jail. Some of you may remember a lawsuit called Ruiz versus Texas that was in place when I became a lawyer, and the whole Texas prison system was on lockdown from overcrowding because of all of the drug cases that were being sent to the court. So it depends. If it's early in a program for intense offenders, well, then you're going to expect it. You're going to expect them to get away from that conduct, but showing up is the key. You can't do anything if you don't show up. Let me talk to my judge friends for just a second. These are the 4 areas that seem to get us, are a little bit different than the normal approach to judging. Collaborative decision-making, relationships between participants, including and the team members, including the judge. I generally, I can't with running 2 programs in person right now with probably about 70. I'm not going to say I remember everybody's name. I remember everybody's face. And at our pre-docket session, I'm reminded of. I mean, I got a list of everybody's name, and so it's you can't. My hard drive has rather limited space on it up here, so I can't remember everything. I just do the best I can and rely upon the excellent team that I have to keep me on track. You have to have boundaries, and there is going to be contact between the judge and some of the participants. So these are some of the things that that the rules of judicial conduct tell us that we need to be particularly sensitive to by participating in a collaborative environment. That doesn't mean you give up your judicial independence. You always have to basically be aware of your conduct as it reflects upon the nature of the judiciary in general. And there are, I think, specialty courts are becoming more receptive, but there certainly are people who have significant concerns, particularly in the area of giving up rights when people enter one of these programs. So here's a couple of the components there's 10 key components to drug courts, and it's a coordinated strategy. So best practices in this area is that, I do listen to people who are much more informed about trauma, about the impact of okay, well, here's the violation. These are the different courses of action. So mental health professional at the appropriate level of training, what's your input on how each option may impact this person's success in our program? Well, we use everything from judicial reward. You need to reward at least twice as much as you sanction. So at every docket, I'm asking who's got a birthday, who's got a baby, who's on track to be promoted next month, who got a new car, who got a new job. So we need to focus a little bit more on the positive, because if I got a certificate for completing a mental health or a drug rehab or a whatever program in the criminal justice system, well, there would be people wanting me out of office, and I'd be on the evening news. Well, that's my world, because I haven't had to deal with these things. But for people who do have to struggle with these things, particularly when they have a lot of interaction with the justice system, them getting any positive recognition, particularly from a power figure, it's a really big deal, and those certificates of completion are treasured. They are treasured mementos, and they are warmly accepted by the people who receive them. So that's certainly something that if you're going to be successful in this area, that is certainly something that you must do. But the judge, when you're making decisions on adjudicative facts, you're the final decision maker. You can consider input from the team, but in preserving judicial independence, then you got to make the disciplinary decisions, particularly if it involves a loss of liberty. And in a certain way, it's kind of like a probation revocation. I don't know about your county, but I get a stack of motions to revoke probation. I don't remember all of these people, and I'm not talking about my specialty program. I sign them, a warrant gets issued, and they get arrested, and they make bail, and the case comes to court, and it gets resolved in the linear fashion, as most cases do. So, in a sense, being in one of these programs, which is much more directed towards the needs of the individual, and I love probation. One of our failings right now is we need to increase I don't know about your county, but we're losing a lot of probation officers to the economy, and it's becoming a problem. So they play a vital role, and many of the programs that I'm talking about use probation officers as the case manager. So the continuity is affected when there's a lot of turnover in a department. So we have to keep those lines of communication and figure out ways to reward these people for the good work, for the good work that they're doing. So, you know, whether it's with police officers or defendants, I mean, there are only certain things. I was stalking around the county commissioner's court the other day. I'm not for family violence. Anybody in here for family violence? Anybody in here for in favor of people getting the crap beat out of them in a domestic situation? Well, I'm not either. But somebody walked up to me with a picture, because I've been seeing a lot of signs in a number of counties, so there must be a new initiative going on, and they wanted me to stand there with the picture, you know, not in my county, and a picture of an abused person. I had to decline. And as it turns out, the DA was standing right behind me. When she saw me decline, and she came up to me and said, "Judge, you did the right thing." So we have to you know, perceptually, if it gives the appearance of impropriety, we've got to stay on the straight and narrow. Your interaction with resources, particularly if they're providing direct services to your participants as a board member. You heard that I served on a number of boards. None of them give direct resources to my programs. And I have read the rules with respect to participation, and there's plenty of ethics opinions on the propriety of serving on a board or serving not on a board, and call the ethics commission, for God's sake. Now, I did some math, and about 2/3 of the time they're going to tell you no, but about 1/3 of the time they're going to tell you yes. And so they're there. They're not going to hold a grudge. They'll answer your question, and we'll all be a little bit smarter about it. Well, there's some limits. So 125 deals with the mental health court programs. We also know that Canon 2 says we have to avoid the appearance of impropriety. That gets back to those relationships I was discussing. What about recusal? I want to talk about recusal for just a moment. Well, the case law is split. So should you recuse yourself after you've discharged someone from a program and be the judge that presides over the probation revocation or whatever other consequences awaiting? Well, it's an easy answer in my county. I've got 20 other judges, and we're probably up to about 12 magistrates now that I can have them set on the case. I have taken a few pleas on cases that I have presided for in a program, as long as I'm not involved in the negotiation. The cases that are pro suggest that as long as you come into the information, this special background stuff, through the normal course of your duties, well, then that's going to be more in line for, and let me just tell you, there's not a Texas case. These are out-of-state cases. But that's going to be more in line with finding that it is appropriate for the judge to set over, as opposed to coming into information at the local county picnic when somebody's coming up to you and whispering in your ear about so-and-so. So a lot of it depends on context. And even in the case where the Tennessee was the state that said, no, you shouldn't preside over the case. Well, then there was an ethics opinion issued by their ethics commission that says it was okay for you to preside over the case. So we don't have a Texas answer, but you just got to know it when you see it. If you're having second thoughts about doing it, then you shouldn't do it. All right, so you're going to hear, I want to go down to that canon 3B 5 through 7. Well, the number 2, we're not therapists, judges, and lawyers. You have to stay in your lane. Enough said about that. But you should not fear program evaluation. Every program I have or I work with, I try to get them evaluated at least once every 3 to 5 years. I want to know, because I frankly don't have, I go to the NADCP conference and I go to most of the Texas Association of Specialty Court conferences. I want to know where there's gaps in what we're doing. So I want a professional to come in who has knowledge and background. You're going to hear from a Dr. Snell later this morning, who's going to talk to you about program evaluation. He evaluated one of our programs recently. We've had evaluations by Texas Christian University. We had I'm having one of the DC universities that is basically the personnel arm of some big federal agency. They came down and did an evaluation. My RISE program has been evaluated about 3 times, mental health probably about 4 or 5 times by now, veterans a couple of times. So evaluation is appropriate. You shouldn't fear it. It does force you to get your house in order before the evaluators to show up to use the rules. Those those twice a year or so meetings where you meet with your staff to talk about the dynamics of your program, they're critical. But let's get to this. Bum, bum, ba-da-da. Ex parte communications. Well, once upon a time, it was a very dreary world out there. It was just a minefield that was rarely successfully navigated if it was shown there was an ex parte communication. Well, so what do you do there? Do you give hand signals? You stand on either side of a glass partition and mouth words, and hopefully you're communicating some information that's useful to a successful journey through a specialty court. Well, that was the rule, but there was an exception for ex parte communications expressly authorized by law. Well, the legislature created under 123 of the government code, it created a drug court statute. That's where all the government code sections, beginning with, I think, with 121, is where all of the listed courts are found. But then, just when Chicken Little was fearful that the sky was falling, in came the superheroes. Justice Bland, sitting right there. She doesn't look like a superhero, but by gosh, you see her get in a phone booth, for those of you who remember what a phone booth is, and spin around in a circle real quick. She looks like the Hulk with longer hair. It was her, and I just asked Christy the name of the commission, the advisory committee, rules advisory committee. We'll go with that. Well, they added a comment that now it expressly authorizes ex parte communications, but now there are still some limits. It's limited to programs that are governed by Section 121 of the Government Code. So you can first argue that if your program isn't listed there, then that could be a problem. But if you look at all the topics, whether it's commercial sex trafficking, drugs, mental health, law enforcement, first responders program, I'm sure there's 1 or 2 I'm missing. There's a way you can cast your program to fit that size 10 foot into that size 8 shoe. So you do have to register. There's registration requirements, as you can see, that has to be done. And so public comments about participants, except for immediate team members, no. Of course, you have to discuss the cases, and yes, you do talk about ex parte information with your team. Again, already talking about how to receive interaction. These are the types of disclosures that we should not be given individual cases to the public. It's kind of just common sense. A lot of this is. And then basically situations that are not related to judicial duties. No. This isn't talking about all the fishermen lying about that 2-pound fish and they're claiming it was 15 pounds. This isn't a one-up situation, and we certainly don't want to be identifying people. And I grew up in a small town where everybody knew everybody, and it didn't take much to figure out who somebody was talking about. So you do have to be a little bit circumspect about that. Again, impartiality. Let's look at attendance at events. Cameo appearances, yes. Prolonged interactions in a social setting, I get a little bit more queasy about that. How can you be having recovery programs at the picnic and you're sitting there drinking a beer in front of all the participants that have substance abuse problems? That's a big no. So, we have to make some sacrifices as well also. There's a lot of lists. There's a few ideas about funding. There is a statute. Jurors can pay their fees if they wish for specialty courts. I'm still looking for that goddamn COVID money. So don't you forget it. COVID money. Say it with me. COVID money. All right. So I know it's out there. I want to add another case manager to my mental health court program. So that seems like a pretty good place to figure out how to do it. Well, I have a video that I don't have time to play, but there is it'll be attached to it's a video about my court, and somehow I've lost, there I am. I've got also there's my references. I put some resources on there, some good places to, the Judicial Conduct Commission, the Texas Bar, they're not with a bunch of long knives. They'll answer your questions. When you start off with a question, I got a cousin who did such and such, and you're probably talking about yourself, but don't let it get that far down the road. But anyway, thank you. It's an honor to be here, and I'll just give you the advice that my dad sent his 3 lawyers in his family. He always wanted to be a lawyer himself. He said, sons and daughter, whatever you do, just don't screw it up. Thank you.